Hello and welcome. In this lecture, we will be exploring public policy exclusion under evidence law. Our objectives are subsequent remedial measures under Rule 407, compromise offers and negotiations, 408, offers to pay medical and similar expenses, 409, please play discussion related statements, 410, liability insurance, 411. Subsequent remedial measures is not admissible to prove negligence, culpable conduct, defect in product or design, warning or instruction. For example, if John puts a warning sign after someone fell on a ditch, that evidence cannot be brought to court should, for example, the victim decide to bring a lawsuit against John by saying, for example, that John has put a warning sign after I got injured in his premises. However, subsequent remedial measures can be admitted for the purpose of impeachment, ownership, or control. For example, in a situation where the accused denies, for example, ownership of a car that was involved in an accident. Now, any subsequent remedial measures that has been taken pertaining to that car may be brought in order to prove the ownership of the car. Under Rule 408, compromise offers and negotiations are not admissible to prove or disprove validity or amount of a disputed claim or to impeach by a prior inconsistent statement or contradiction. What this means is when parties negotiate because there's an issue that they're trying to avoid to take it to court, court will involve litigation, which is expensive. It involves lawyers, it involves judges, juries. Now, the court usually encourages the parties to solve their differences outside of court before it is brought to court as a matter of last resort. Now, if the parties engage in negotiations and for some reason those negotiations fail and the case makes it to court, those negotiations that took place while the parties discussed the case or discussed the agreements cannot be brought as an evidence of any compromise offers. Under Rule 409, offers to pay medical bills and similar expenses are excluded. For example, if an injurer offers to pay the medical expenses of the injured victim party, now such offer to pay cannot be brought to court as an evidence should the victim in this case sue the injurer at a later opportunity. Under Rule 410, any plea discussions, related statements cannot be brought as evidence in either criminal or civil cases. Now, because usually the court encourages plea discussions, and any time that a party engages in such discussion with, say, the prosecutor or with the court, such discussions cannot be brought as evidence during a criminal or civil case. And such discussions can be in the form of a guilty plea that was later withdrawn or a nolo contendere plea, which really just means a plea where someone has, in this case, accepted the conviction. However, they have not admitted the guilt. Or any related statement in proceeding or plea discussions. So whenever there are plea discussions, any of the agreements that take place cannot then later be brought to court as an evidence. Now, exception is in for fairness in this case, enduring perjury. Now, if a party lies under oath before a court, then that evidence can be brought before court in order to prove perjury. Finally, liability insurance cannot be brought as an evidence in order to prove that someone, a perpetrator, has caused an accident to a victim. For example, the victim cannot say that X or Y is guilty of bumping into my car because they have liability insurance. They can then make payments of the damages to my car. Such evidence will not be admitted in court. The exception is to prove a witness bias, prejudice, or proving agency, ownership, or control. For example, if the accused has a car and that car has been involved in an accident and the accused refuses that that car is not their belonging, then the court may then call for evidence of the liability insurance, which will then prove that the car indeed belongs to the accused.